2019 came into force on 20th July 2020. That is exactly 1 year of completion of coming into force of this 2019 Consumer Protection Act. This 2019 Consumer Protection Act, it provides for enhanced protection to the consumers, taking into consideration the booming e-commerce industry and the modern methods of providing goods and services such as online sales, in addition to the traditional methods. Consumer Protection Act 2019 prima facie appears to be more friendly than the earlier Consumer Protection Act. However, the test of time will prove the fate of 2019 Act. And we cannot have a better person than Professor Ashok Patil to address on this topic. We are extremely happy to have Professor Ashok Patil, Professor of Law and Chair, Consumer Law and Practice, National Law School of India, University, Bangalore, as our resource person. On behalf of KSLU's Law School, I extend a warm and cordial welcome to Professor Ashok Patil. And I also extend a warm welcome to our Honorable Vice Chancellor, Professor P. Ishwar Bhatt, and also a warm welcome to Professor G.B. Patil, Professor C.S. Patil. A hearty welcome to our faculty coordinators, Dr. Bhima and Dr. Archana. And I also extend a warm welcome to all our dear faculty members and dear students. Thank you.
Thank you, ma'am. I also extend a hearty welcome to you, ma'am. Now I request Dr. Bhima Bhai Mulge, Assistant Professor, KSLU's Law School, to kindly introduce the resource person.
Professor.
Thank you, Ramya. Good morning to everyone. I feel it my privilege and honor to introduce Professor Dr. Ashok R. Patil, Professor of Law and Chair, Consumer Law and Practice, Ministry of Consumer Affairs, Government of India, and Coordinator of IQAC and NIRF. Sir has completed his BSc degree in 1993. Thereafter, he completed his LLB in 1996, LLM in 1998 with first rank, and PhD in 2006. Sir's more than 50 articles were published in reputed national and international journals, and more than 8 books to his credit. He visited more than 15 countries and presented more than 30 well-researched papers at the international level. Sir has organized more than 41 training programs for the benefit of NGOs, consumer forum members, teachers, and others. He actively involved himself into various research activities and successfully completed more than half a dozen of major research projects. Sir is a member in many national and international institutions and government bodies and received many awards and fellowships. Important among them are received UGC FIP Fellowship in 2005, Asian Law Institute's Fellowship in 2010, received prestigious National Award of Legal Education Innovation by Society of Indian Law Firms and Menon Institute of Legal Advocacy and Training in 2013, received International MacGenet Award in 2014 at Cape Town, South Africa. With this brief introduction, on behalf of Karnataka State Law University, Hubballi, I welcome Sir for this function. I welcome you, Sir. Thank you.
Thank you, ma'am.
Thanks.
Thank you, ma'am. May I request Professor Dr. Ashok R. Patil, Professor of Law and Chair of Consumer Law and Practices, NLSIU Bangalore, to deliver lecture on 1-year completion of Consumer Protection Act 2019 Achievements and Challenges. Please, sir.
Thank you. Let me share my PPT. Right. At the outset, my sincere thanks to Vice Chancellor Professor Ishwar Bhatt, Registrar Muhammad Jubeer, my pet teachers, C.S. Patil, G.V. Patil, Ratnabaram Gowda, my friend Rajendra Hittangi, and all the staff members and student friends and all the participants who are attending this particular webinar. The topic is 1 year completion of Consumer Protection Act 2019, achievements and challenges. As you know, we were having a old law, Consumer Protection Act 1986, and later looking into its implementation, lot of loopholes we found. Then on that basis, Minister of Consumer Affairs thought of implementing or coming out with a new legislation. So earlier, why I know all these things, because from day one, since 2008, I involved in drafting of Consumer Protection Act bills, a lot of things, because I'm heading Minister of Consumer Chair, Government of India, Ministry of Consumer Affairs. So in that regard, during Congress government time up to 2014, we were working on amending the 86 Act, looking into during that time whatever loopholes were there. Later, BJP government came, then instead of amending every section throughout the legislation, let us come out with a new legislation. Then Consumer Protection Bill 2015 drafted, and it was introduced in the Lok Sabha. And in Lok Sabha, again, it was referred to standing committee, parliamentary standing committee. Again, you know that in parliamentary standing committee, around 25 people, 25 MPs of different political parties sitting and hearing all the experts of throughout India. So I also went and submitted my views before the parliamentary committee. Usually it happens in parliament building. And like that, all the stakeholders are also called and took their view. Again, this parliamentary committee collected all the information, prepared a report, submitted to the parliament. And again, it was referred to Ministry of Consumer Affairs. Usually, amendment or new legislation starts from the concerned ministry. So it started in Ministry of Consumer Affairs, Secretary, Additional Secretary, Joint Secretary, Cabinet Minister, State Minister, all together. First they decide, yes, there is a need for amendment or new legislation. Then it starts drafting of bill, calling all the experts throughout India. And after that, it has to approve through proper particular departments, cabinet it has to pass, then finance it has to pass. Afterwards, in the form of a bill, it enters the Lok Sabha. And in Lok Sabha, it was referred to Parliamentary Standing Committee. Again, Parliamentary Standing Committee submitted report to Parliament. Then again, it came to the Ministry of Consumer Affairs, Government of India. Again, we sat and whatever good things reported, mentioned in the report, we took those suggestions and prepared another bill, that is Consumer Protection Bill 2018. During this time, there was a case pending before the Supreme Court, that is UP Consumer Bar Council versus UP government. So in that case, the Supreme Court Chief Justice of India constituted a committee under the chairmanship of Justice Arjit Pashayat and 2 members. What is their job? They have to visit all the states, all the state commissions, district commissions, meet the members, presidents, meet the consumers, observe the procedure, observe how these appointments have happened, what is their salary, all those things he has to look into and submit a report to Supreme Court. And on that basis, Arjit Pashayat committee submitted its report to Supreme Court. And on that basis, Supreme Court directed again Ministry of Consumer Affairs to frame rules on appointment of the members and presidents and on their salaries. Again, central government Central Consumer Ministry constituted a 6 members committee to frame rules on this. I was also one among them. We framed rules for the appointment of the members, presidents, and also the salary. Again, it was submitted to the Supreme Court. Supreme Court issued a guidelines to all the chief secretaries of all the states to follow these rules. Meanwhile, the 2018 bill submitted. Why this bill was not passed? Because during that time election announced. 6 months lapsed. Then again, the ministry submitted a Consumer Protection Bill 2019. Then it was passed in Lok Sabha, Rajya Sabha. Then it went to President sign. Then it was notified into the Government of India Official Gazette on 9th August 2019. So usually when it will come into force, it is not on the basis of when it is published in the Official Gazette. It will be mentioned in the Act itself when it will come into force. Even though it was published in Official Gazette on 9th August 2019, it was not immediately came into force. So Section 2, Clause 3 mentioned that it will come into force when the Minister of Consumer Affairs, central government notifies the sections, section-wise or chapter-wise or whatever they territory-wise. So on that basis, first time in 20th July, the central government notified half of the provisions of Consumer Protection Act and rules framed under those sections. And on 23rd, e-commerce rules notified, 23rd July. And 24th July, rest of the sections and the regulations are notified. So from 24th, everything was on track and it was in force. So 20th July is the first time, because we were working since 2008. It took us to reach enforcement only on 20th July 2020. So that is the background. And also the amendments always took some of the national surveys. One is CUTS International Survey in 2012, and another one IIP, Indian Institute of Public Administration, New Delhi in 2013. Those observations are also counted. And also some of the writ petitions are filed by National Law School students and even consumer cases. Those feedback also the central ministry got. Comprehensively considering all these things, the central government came out with this legislation. So lot of merits in the Consumer Protection Act, and compared to civil code, lot of merits, and it's a consumer friendly, speedy disposal, time saving, less expensive. So because of that, the people are coming to the Consumer Commission to file a case. Very important aspect I want to stress here, because majority of the students are involved in this webinar. Why law students should expert in Consumer Protection Act 2019 compared to other law subjects. Thousands of subjects are there. You are studying around 50, 60 legislations in law school. Why you should give more importance to the Consumer Protection Act 2019 compared to others are also important. But here you will learn a lot of things. First thing, if you yourself is a consumer, you can go to Consumer Commission and file a case. It's here Civil Procedure Code 1908, Evidence Act, then criminal procedure. All these procedural things are not applicable here. So once CPC is not applicable, everything is easier. So as a student, while learning in law school, you have a right, you are capable to file a case. This particular Consumer Protection Act is framed so that even layman can file a case and argue his case. In that way, this is framed. So law students are better than layman. So that's why I'm stressing on this. You are capable, you can do a lot of changes in the society. Whenever you suffered, yes, you have a right to file a case. Even others suffered, you can help that sufferer by filing a case and fighting a case against the wrongdoer. So here, it's a normal drafting of a complaint. So drafting skill you will learn, then filing of a complaint. Here up to 5 lakh rupees, no court fee. There is no need for you to pay from your pocket. So no court fee is paid to the Consumer Commission up to 5 lakh rupees claim. So no expenditure to learn or to get this particular skill. And argument. So if opposite party appeared by the advocate, then 2 days prior to the argument, final argument, they have to submit written argument so that student can learn what are the defenses he is taking, what are the attacks he is making. On that basis, you can learn yourself and prepare your argument. So written argument should be given by the opposite advocate to the complainant. Then how to face the questions from the presiding officers, president or member, or even opposite party advocate or opposite party, that also you will learn. And it is a consumer friendly environment. It is a consumer friendly environment. It is not like a civil court. Legislature kept in mind while drafting the act, rules, regulations, no words should be used which are used in the regular court. Here we are not using as a court. Here we are using it as a commission. Here we are not calling them as a judges. They are presiding officers, president and member. Here we are not calling the application, the complaint as a plaint or written statement. So here complaint and objections. So every stage they kept in mind every person who enters the consumer forum or commission, he should feel free, cool, and argue his case peacefully. And also if you look into the infrastructure within the Consumer Commission, even the presiding officer should not use the gown as the judge is using. They should not use a chair, high-ended chair. Usually the civil court judge uses it. And the stage on which they are sitting, it should not be more than 3 centimeters. So like that, a lot of infrastructure is also mentioned. So object is whosoever enters in the Consumer Commission, he should feel free, he should argue his case and get the justice. That is the hidden object of the hidden, not expressly expressive object of the legislation. That's why I'm stressing on this. Students, during this 5 years or 3 years, you can learn drafting skills, you can learn filing, and even how to face the bench clerk in the court is also skill. How to file, how to stitch. These are the small things that you can learn while doing the course. So when you complete your law course, you should be final product. You should be capable to handle your case. So to that extent, you should equip yourself during this 5 years and 3 years. That's why I'm saying the law students should expert on CPA 2019. And during these 5 years, you can learn all these skills. Now, skills are the very important thing. Degree is not counted. Your ranks may not be that much weightage when you enter the practice. Practice, when you start your practice, your skills counts. Even Prime Minister in all the professional fields, he is stressing on the skills, not on degree. Paper degree is useless when you enter the profession. Profession is completely different. So that's why concentrate on skills than just writing an exam. Exams are also important, but all these activities are also important, extracurricular activities in law school. Then coming to other aspects. So yes, the constitution at the international level, United Nations Guidelines on Consumer Protection, 1985. Afterwards, in 1999 and 2016, 2 times amended. So those broad guidelines are adopted by all the members of UN, and India is the first country coming out with a new legislation in 86. independent redressal system exclusively for consumers is the first legislation in the whole world that is India enacted and implemented. And the powers, the rights, the fundamental rights are there to the consumer. And also the right to do business is a fundamental right, but it's not an absolute fundamental right. State can impose reasonable restrictions on the trade. So to that extent, for that purpose, all these welfare legislations are enacted. And also Article 21, right to life with dignity, means without exploitation. Then there are some directive principles. 38, state should secure a social order for the promotion of welfare of the people, duty of the state to raise the level of nutrition. So all these things together, state has a duty towards the protection of consumers. So all these things already I have referred that two national surveys and Supreme Court judgment. It's a 2016 judgment, 3 judges bench. Then NLSI students filed a PIL and consumer complaints. And during Congress government time, just amendment later, it was referred to Standing Committee 18 Bill 2019. Now it is Act. So this is a background. So new legislation is having 8 chapters, 107 sections. What is the difference between 86 Act and 2019 Act? 3 new chapters are added. One is Central Consumer Protection Authority, second one mediation, third one product liability chapter. So these 3 new chapters are added, and whatever words used in these new 3 chapters, those words definitions entered in section 2 definition part. So this is the main changes from 86 to 2019. Other than this, the existed 86 Act, majority of the sections copied and pasted in 2019 with changes, with amendments, or with the new version, so that loopholes in the 86 can be removed. So it may be on pecuniary jurisdiction, it may be on territorial jurisdiction or enforcement. On many aspects, improved version entered in Consumer Protection Act 2019. So we'll look into those things also. And just I'm taking these 3 new chapters first, and later what are the changes in the new version of the old sections. So central authority is established at the national level, and immediately it was established presently. The Miss Nidhi Khare, Additional Secretary, Minister of Consumer Affairs, Government of India, appointed additional job is she is a Chief Commissioner of the Central Consumer Protection Authority. Immediately she started working on lot of things, and even during COVID time, lot of misleading advertisements came. So that also notices are issued. So what is the purpose of establishing this authority? Do you think that is it a white elephant? Another authority, already a lot of authorities are there, and this is another one. So the object behind establishing this central authority, why not this authority established in 86 Act? So when 86 Act was enacted, during that time, whatever position was there, on that basis, legislators enact the law. During that time, there was a MRTP Act, Monopoly Restrictive Trade Practice Act, and there was a MRTP Commission under that used to take care of the unfair trade practice and restrictive trade practice. But later that act was repealed and Competition Act came into force, repealing that act. And Competition Act is not handling the business to consumer disputes, any unfair trade practice. So then central government thought of, yes, we need a central authority here. And this central authority, when we were drafting, so each provision is discussed in depth before putting it before the Lok Sabha. So we looked into FTC, Federal Trade Commission, US and Australian, some of the regulatory authority, and also the existed authorities in India. What are the good things are there? Those things we wanted to bring it here. And it has a suo motu power. central authority is having a suo motu power. By looking into the newspaper or TV news, they can admit as a case and start doing investigation. It has an investigating wing. Lot of powers are with the central authority. So this authority will change the scenario of consumer protection in India. And another very important thing is, already you may say that already some regulatory authorities are there. Why not this one? So wherever, assume that if there is a adulterated food product found, complaint is given to the central authority. Then if it is found that prima facie it is adulterated or poisonous, then they may refer it to FSSAI, Food Safety and Standard Authority of India, which is an expert in food. So they will refer it to the FSSAI, and FSSAI do investigation because they are expert. Expert opinion will be given to the central authority, and then they will take action. So coordination between the existed authorities also included here. And also there was the tension that they are taking over or overlapping of consumer commission powers. So that also they kept in mind and keeping it away. So here, against the decision of the central authority, aggrieved party can file an appeal to the National Commission. That provision is also given. And central authority will not look into all individual consumer cases. It will look into only the where unfair trade practice is happening to the class of a consumer. Consumer as a class word is used. So wherever consumer as a class is affected, then central authority interfere. Otherwise, if individual consumer is affected, then it may not interfere in that. So individual consumer is affected, then he has to go to the Consumer Commission. So even though if they file complaint to the central authority, it will not consider. So unfair trade practice, misleading advertisements. So all these things which are affecting to the whole society, those things are considered, and it will do investigation. So that is the strength of the consumer authority, central authority. Another one very important difference I want to express here: to file a complaint before the Consumer Commission, if you found that there is a misleading advertisement and to file a case against that misleading advertisement on cosmetics, you know that it is impossible, and science also says, laws also says you cannot do these types of advertisement, even though they are doing. Then to file a case against that manufacturer or the advertiser under the Consumer Protection Act, under 86, and now also to file a case against that, first you have to purchase that cosmetics, apply on yourself, suffer yourself, then you get a right to file a complaint against that wrongdoer. So you have to satisfy the consumer definition, consideration. So that problem is not here to file a complaint. So there is no need for you to prove yourself as a consumer to file a complaint before the Central Commission. So just looking into the misleading advertisement, record it, support all the documents which says misleading, and submit complaint to the central authority. Then they will do investigation. They are not asking that, have you suffered? Have you, receipt is there or not? So all these things will not look into. So that is the main difference between the authority and commission. So they will take it very seriously and do investigation. So that's why this is peculiar and very strong central authority. Then coming to mediation, yes, section 89 of CPC, from that it was evolved, and for arbitration and conciliation there is a legislation, but for mediation no legislation. Only the rules are framed by the High Court or Supreme Court, those are there, but no, not in legislation. So that's why first time the Consumer Protection Act, one independent chapter on mediation is recognized. So mediation, as you know, a neutral party is settling the matter between the two parties, the disputing parties. So mediator is a neutral party. He's not giving his opinion. He is understanding both parties' mindset. He is bringing them neutral. He is neutralizing them. Then tries to settle the matter amicably, no force, no coercion, and at the end, it's a win-win position. Both parties are happy. Both parties are agreed. Both parties are signing on that, and mediator also signing on that and submitting before the commission. Commission puts its seal and signature. That becomes the order. And once a mediation, on the basis of mediation, decision is given by the commission, it cannot be, it is not appealable. The appeal is closed here. So because it is a voluntary settlement. So that is a mediation is recognized, because nowadays, even though we say that case has to be disposed of within 3 months or 5 months, 3 months from the date of notice served to the opposite party, case has to be disposed of. That is not happening. And 5 months in case of lab test, that is also sometimes not happening because of many reasons. State governments are least bothered. Appointments are not happening regularly. So when they know that when they are retiring, well in advance, before 6 months, they have to start the appointment procedure. That is also mentioned under the Act, but no state is doing that. So that's why the vacancies are there. A lot of things are there. So that's why delay is also happening. So because of all these things, if there is a mediation clause is there, mediation, if both parties are ready for mediation, then commission let them refer it to the mediation, so that there should not be any delay in settlement. So that is one thing. One example I want to share with you, that in Karnataka, maybe in 2016 or 17, around 60% of the district commission members and presidents vacancies were there. And no government is bothered. Then we did a empirical research. Consumer Protection Act 1986, implementation of Consumer Protection Act 1986 in Karnataka state. So report says around 60% vacancies. 2 new districts, 3 new districts were not having district commission. Then infrastructure was not given. With that report, I went to the Met and additional secretary, government of Karnataka, and they said we are busy. We have to do other work. We don't have time to look into all these things. 1 hour I discussed with the person, and later I came back. I cannot quarrel with the bureaucrat. I came back and I discussed with the students what next. Then we decided to file a PIL, public interest litigation, before the Karnataka High Court. And always kept in mind, whenever students doing research, empirical research, up-to-date information, if you go to the court, High Court, they will appreciate that. They will encourage you to come out with, if any loopholes is there, they will encourage you to bring that, or they will try their level best to argue your case and help wherever you are failing. And ultimately, they want justice to the cause which you brought to the High Court. And in our case also, the Chief Justice of Karnataka High Court issued a notice to the Chief Secretary, as well as the Additional Secretary of Consumer Affairs, as well as the State Commission President. And next hearing itself, the Chief Justice ordered within 6 months, you have to appoint all these members, provide infrastructure. So one who said no to me, same person appointed all these members. So this is the capacity of the students, university. So make use of it. And by doing this, you will also learn skills, drafting skills, handling the people, arguing the case, all these things. That's why here you are also helping the society. As a university, you have a duty towards society. As a student, as a faculty, we are also having a duty towards society. By doing this way, we can self-satisfied that yes, we have done something to the society. So this is a way you can do. Coming to the product liability, yes, there was no specific product liability chapter in any of the legislation. Hence, it was mentioned here, when manufacturer is held liable, when seller is held liable, when product service provider is held liable, what are the exceptions, all these things discussed in this. And offenses and penalty chapter, It is connected to central authority. Central authority, if it finds that misleading advertisement or unfair trade practice, it will file a complaint to the magistrate court, criminal court. And if it is punished, then imprisonment and penalty. So which was not there under 86 Act. So now central authority directly file it will do its investigation, then it will file a complaint to that particular territory magistrate court, and if it is proved, imprisonment and penalty. So that is the new thing has done. So miscellaneous state making rules or all those things are there. So these are the rules framed. And last two, consumer protection salary allowance model rules, the consumer protection qualification. See, these two things, rules are made when the Supreme Court directed the ministry to frame rules. These same rules issued by Supreme Court to all the chief secretaries. Meanwhile, this new act came and the same thing is under rules now. So consumer already, you know that it along with law of torts, this subject is taught. Now the Consumer Protection Act is different. So even now, Bar Council of India has to think that one independent subject has to be taught on Consumer Protection Act. That much potential it is having. In National Law School, Bangalore, since 2008, when Consumer Chair is established, I'm teaching one independent compulsory course on Consumer Protection Act to NLSIU students. And like that, many other national law schools are also teaching. So when it was 86 Act, now 2019 is a bigger than 86 Act. It covers everything and it is reaching every person in the society. So it is more important. So that's why if we make it independent subject, it is more helpful for the students as well as to the society. So in that, the consumer, just I'm giving you the broad view. Another thing, why it was added in the law of torts. So law of tort, as you know, uncodified law, common law system, things, principles are involved. So those common law principles adopted, brought under legislation. So majority of these principles recognized under the Consumer Protection Act. So this is more effective than you cannot see the development of law of torts in India. Only for one independent course, for law course, we are studying how much you have used in the practice is very negligible or nil. But you can use Consumer Protection Act effectively, same law of torts principles under this legislation. So that's why this is very, very important subject in future. So we have recommended to BCI also, and independent university, deemed university, it is their privilege. It has a power. They can do whatever they want. So in that angle, they can consider. And consumer, in summary, consumer definition, whosoever buys a goods or hires a service for consideration is a consumer. So purchaser and seller. Purchaser is a consumer. And if the purchaser purchases goods for, let us take an example. If father purchases a laptop and given to this daughter is injured by defective laptop. So daughter is not party to the contract. Even then, daughter is a consumer under consumer definition. That is the middle part, includes any user with the permission of the purchaser. So liberalization of locus standi is recognized here. And exception is resale and commercial purposes exception. And service also the same way. So if father admitted his daughter to the hospital and there is a medical negligence, father paid the fees to the hospital, then if daughter suffered, then daughter can also file a case against the hospital or doctor. And explanation clause is given the commercial purpose, that whosoever purchases goods or hires service for self-employment and whatever he earns that is used for livelihood, then that person is still a consumer. And this particular second explanation clause is added in 2019. It clarifies whosoever buys goods online or offline, all types of things. So this is the particular consumer definition one must know. And coming to other aspects, because now time is 11:15. So within 10 minutes, I will take some very important aspects into what are the new changes has happened and which is useful. So territorial jurisdiction is expanded. Earlier, CPC provision copied and pasted here. Only additional thing was where the branch office is situated, except that it was same as CPC. When we were amending the legislation, I gave an example in one of the national survey, only 0.3% of the aggrieved consumers are approaching consumer forum. What may be the reasons behind it? One of the reasons is this territorial jurisdiction also. So if a person from Dharwad went to Bangalore, purchased goods in Bangalore, came back to Dharwad, and if it is a defective, then he should, if he wants to file a case, then he should file a case where he purchased it or where opposite party works for gain, where cause of action arose. If nothing is falling in Dharwad, then no person going to Bangalore and file a case. So that's why they will leave it. Even though he knows his right is violated, even then he thinks that, no, there's no need for me to go to Bangalore and file a case. So that lacuna was there. And in that regard, I requested the committee that let us add where complainant resides or personally works for gain, there also the case can be filed. 2 days they were not accepted this particular proposal. Again, I gave some of the other legislation. Wherever weaker party is there, legislation has to help that particular party to achieve the object of the legislation. Ultimately, they agreed. The complainant resides or works for gain, there he can file a case. Now, the same example what I have given, you can file it in Dharwad now on this particular topic. And pecuniary jurisdiction is increased. Earlier, up to district commission, or in district commission, up to 20 lakh, then state commission 20 lakh to 1 crore, and above 1 crore national commission. So if your claim is more than 20 lakh, you have to directly go to the state commission under the 86 Act. That's why we thought, let us keep the consumer less expensive. Let us be comfortable in his district itself. So if we increase the pecuniary jurisdiction, 90% of the cases will be in that district. So up to 1 crore is a huge amount. So every time we cannot amend these things. So they kept it 1 crore. So here another very important thing is made to decide which commission has a pecuniary jurisdiction, that is based on the value of the goods or services paid as a consideration. This is very, very important. Earlier under 86 Act, it was claim, total claim. On the basis of total claim, the territorial pecuniary jurisdiction used to decide. Now it is on the basis of value or value of the goods or services. Say assume that 99 lakh rupees car you purchased and value of the car is 99 lakh. Then pecuniary jurisdiction is district commission only. Then you may ask the question, if that is the case, can he claim more than 1 crore compensation? Yes. Consumer can claim more than 1 crore compensation before district commission. Pecuniary jurisdiction is restricted only to file a complaint. It is not discussing anywhere your claim. So you can claim more than 1 crore before the district commission. So it was challenged. A lot of things has happened at the national level. Some states have wrote a letter. Then ultimately ministry has discussed on this particular point. So parliamentary committee also stressed on that. They have mentioned increase the 1 crore, many documents, and ultimately legislators' intent was like this. Then the central government not thought of amending any of these things. And also, many access, we can say. So this is the section 34. Value of the goods or services paid as a consideration does not exceed 1 crore. It is only for the purpose of filing the complaint only. It is not applicable for total claim what you are asking for a compensation. It may increase more than 1 crore. Court fee is very, very negligible compared to the civil code. And why I'm stressing students, you can file a complaint. There's no need for you to ask your parents, pay me more pocket money. I want to file a case, to fight a case against injustice. So no need to ask more money. It is up to 5 lakh rupees, no court fee. So only the paper drafting, all those things are there. And other amount is also very negligible compared to civil code. 2,000 up to for 1 crore before district commission, state commission up to 10 crore, 6,000, about 10 crores, 7,500. Very, very negligible amount. So central authority I have discussed. Then investigation wing is there, recall of goods, withdrawal of service power is there. Then directions, issue directions and penalties against wrongdoer, search and seizure order. So all powers are with CCPC. Deficiency definition amended, 2 clauses are added. I'm referring only 2 clauses. It is only deficiency is applicable to the services. Here, any service, it is not applicable to goods. So any act of negligence or omission or commission by such person which causes loss or injury to the consumer is considered as a deficiency. Deliberate withholding of relevant information is also deficiency. If you read the Consumer Protection Act, it is so strong. Till today, nobody exhausted using this particular act. Even whatever powers given to the presiding officers, they have also not used exhaustively. So once both the things happens, then we can see a lot of changes. These 3 provisions, these 3 clauses are added in unfair trade practice. Not issuing bill or cash memo or receipt is considered as an unfair trade practice. Refusing after selling goods if it is a defective is unfair trade practice. Disclosing to other person any personal information giving in confidence by the consumer is also unfair trade practice. So all these things very, very important. And e-commerce is completely recognized. Electronic service provider rules and regulations are framed. Misleading advertisement is clearly given. And endorser is also recognized. See, on misleading advertisement or endorsement, during when it was introduced before the parliament, Lok Sabha, during that time, Maggie case went to National Commission. In Maggie case, first time central government filed a consumer complaint to the National Commission against Maggie case. So we did a research and submitted to the ministry. See, you have a right to file a complaint, kindly use that. It's great that they did it. And in that case, Amitabh Bachchan and Madhuri Dixit got notice on misleading advertisement. So when this bill was put before the Rajya Sabha, then Jaya Baduri raised objection. No, you cannot hold liable the endorser. Endorser are innocent. Then the then Minister Ram Vilas Paswan defended why we have added endorser liability. If anybody pays you huge money, whatever they say, without applying your mind, due diligence, if you do advertisement, public trust you, public believes you, and they follow you. So that's why you have also responsibility while doing the advertisement. So without changing that, the bill was passed. So punishment for false and misleading advertisement, imprisonment is there. Unfair contract is new definition added. And another very important thing is during COVID time, online filing is recognized. E-Dakil software is installed in National Commission as well as State Commission and District Commission. So electronic service provider, the notices can be served. Then fees can be paid online. Filing can be done online. And even parties are busy with the permission, video conferencing can be done online. So all types of flexibility looking into the present position that is also done. The enforcement of the orders, there was a loophole. Under 86 Act, District Commission was not having power to execute its own order, final order. So that power was not there. Now they have given, as if how civil court is having its execution power. Similarly, now District Commission or State Commission, National Commission is having a power to execute its own order. Penalty for non-compliance, this is more stronger than the earlier one, because if opposite party is not following the order, notice is served, arrest warrant is issued to the opposite party, and immediately they are coming and depositing the amount. One last, landmark judgment I want to put before you, that access to justice, Supreme Court said access to justice is a fundamental right, and laid down 4 main facets of the essence of access to justice. First one, the state must provide an effective adjudicatory mechanism. Second one, the mechanism so provided must be reasonably accessible in terms of distance. The process of adjudication must be speedy. And fourth one, the litigants' access to the adjudicatory process must be affordable. If you look into all these 4, the new legislation, Consumer Protection Act 2019, satisfies all these things. So this is a very important document. And challenges. Yes, Consumer Protection Act is central legislation. Rules are framed, and central government cannot interfere in the administration of the state government. It has a limitation. It can request, but it cannot go to each state and implement Consumer Protection Act. It is impossible. So in that angle, it's a challenge in India that every state has to implement Consumer Protection Act effectively. Then only the object of the legislation will be achieved. Otherwise, it is only on paper. Again, to implement that, again, the NGOs, legal aid clinics, public, all together we should fight for implementation at the state level. And a lot of online, the electronic media is recognized, so physical and digital infrastructure should be given as per the new legislation by the state government. And also now the central ministry, Minister of Consumer Affairs, is also helping the state governments in establishing a mediation cell. They are collecting all the information, how much cost it may cost. So Chief Secretary is sending that information to the central government, and central government is releasing, especially on the mediation part, that is moving. So these are the challenges. India is a big country, and different states, different culture. It has to reach to the grassroots level. In India, it will take a little bit of time to reach, but I'm sure it will reach to every corner of the country, and state governments will implement effectively. I'm giving the Karnataka example. Karnataka government has done good job in this, especially implementing those rules in Karnataka. Appointment procedure also started. A lot of changes has happened in Karnataka. We may say that compared to other states, Karnataka is a good example in implementing new legislation, especially in state commission. The registrar or president or the secretary for Ministry of Consumer Affairs, they are excellent. They are working hard. in implementing this particular legislation. So with this, thank you very much. A lot of things are there to tell, but time is a constraint. I'm closing here, and I'm happy to take questions from your side. Thank you.
Thank you so much, sir, for an enlightening and thought-provoking lecture. There are a few questions that are raised by the participants. I would like to raise the question on behalf of the participants. May I, sir?
Yeah, please.
Thank you, sir. The first question is, why restaurant hospitality services are excluded from the purview of CPA?
Which one?
Why are the restaurant and the hospitality services excluded from the purview of CPA?
See, restaurants and hospitality excluded from the Consumer Protection Act. On what basis? It is not excluded. It is there. Hospitality services are also covered. See, ultimately where it has to be mentioned. So if it is a goods are sold, then goods definition it should cover. Then if it is a service definition it should cover. In services, only two things are excluded: commercial purpose, and if it is a free of cost, it is excluded. Only those things are excluded. Rest of the other things included. So that is not excluded in the new legislation or in old legislation.
Thank you, sir. The
Yes,
second
next.
question is, who all can be made liable for a misleading advertisement?
In misleading advertisement, if let us take example of Complan. If you drink Complan twice a day within 1 month, 1 feet height will increase. So one who is advertising, first of all, manufacturer who has given this script to them, or if advertiser is also involved, whosoever intermediary involved. So usually expressly what we got, one is a manufacturer we know, another one is a endorser. So both people will be held liable jointly and severally. So here we are saying jointly and severally. If the endorser wants to escape from the liability, he has to prove due diligence. There are some exceptions. So he has to prove that and escape from that. Otherwise, he is also held liable. So these are the, depending on the each advertisement, whosoever involved, jointly and severally, we can held liable for them.
Thank you, sir. The third question is, according to India's Home Ministry, cybercrime has increased by 86% between the month of March and April 2020. And personal data is most attractive target as millions of consumers have fallen victim to the malwares. How e-filing of complaint helps in safeguarding consumers in pandemic time when no courts were open, requesting to throw some light on e-filing registration procedure.
Yeah. See, during COVID time, courts are also closed. See, especially you can see the one of the many video documents of Justice Chandrachud. He is fond of all these things. He is concentrating on all these data protection, all those things. Here, one way we have to give protection to the consumers. If you say that everything should be closed, then how consumers can approach Consumer Forum, Consumer Commission to fight a injustice? So that's why they started e-filing. And we have to go with the technology. Otherwise, we are out of the competition in the whole world. So as an individual, as an institution, it's a competition. Along with the competition, we should protect the data also. So data protection is also very, very important. One bill is pending, and Justice Sri Krishna committee submitted report that is also working on that. So still pending, and we have already added. You should appreciate Consumer Protection Act, where it is already said that it's a deficiency in service if anybody discloses that particular information. Under the Consumer Protection Act, you can bring them. See, always the government is also trying their level best. neighborhood enemies are there. These people are collecting data. They are, lot of planning is happening. So always we kept in mind, ministry also kept in mind, data protection is very important thing. So they are trying their level best, and security, all those things, especially here, the Consumer Commission, these softwares are not done by private people. These softwares are done by NIC, National Informatic Center, which is a government body. So always they kept in mind to take care of all these things. So in looking into all the limitations, they are helping the consumers. They are implementing the e-filing. So even high courts and Supreme Courts are also doing the same thing. NIC has designed that. So they are trying their level best to protect the things. And if anything happens, usually it will not happen. But any hacker or any person comes, there are other, the IT Act is there that will take care of those people.
Thank you, sir. The other question is, recently WhatsApp has updated its privacy policy by formulating it mandatory on consumers like to take it or leave it. So what are the remedies available to the consumers under the Consumer Protection Act regarding this type of standardized contract?
See here, social media. In social media, first you have to prove that whosoever is using social media, are you consumer under consumer definition or not? To satisfy consumer definition, first thing is you have to pay consideration. Are you paying consideration? So if you are not paying consideration, there is a good defense from other side that no consideration, the complainant is not a consumer, and it will not fall under the Consumer Protection Act. That is one way. Second one, we are fighting, we are doing research, how we can bring these social media into the picture. So these social medias are not a charity people. Every year, their shares are increasing, profit is increasing. How is it possible? By doing free service, how they will get that particular profit? There is some other ways where they are selling the data or using some words which are not understandable to the user. So they are making that particular benefit and they are doing that. And also, see, nowadays, day by day, consumer is also should aware everything law will not protect you. As a diligent consumer, diligent user, how many of us saying yes, yes, yes before reading terms and conditions? Nobody reads. Till today, 99% of the whosoever install any app in your mobile, it asks your email address, everything. You say yes, 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 install it. Nowadays, without WhatsApp, without Facebook, no life. So that to that extent, we have depending on them. That's why now they are exploiting, making use of that. So as on now, they cannot fit into consumer definition. They will escape, but in civil law, yes, we can fight. But under Consumer Protection Act, you don't have a right at present. But we are trying to bring them also, but it may take time.
Thank you, sir. The next question is, as consumer matters involve pretty amount claims and sometimes it will be expensive for the consumer to go to the district headquarters, the expense may itself be more than the amount of compensation claimed. So taking this into consideration, the consumer must sit on his right. In my opinion, there is a need for commission to set up at the taluka level. So please provide your view on the same.
See, already under new legislation, two things have already done. E-filing, sitting in your village, you can file. Nobody stops, because nowadays in villages also they are purchasing goods from Amazon, Flipkart. Same way, while doing in sitting in home, they can do that. So that problem is solved. There is no need for you to go to the district place and file a case. If in future the physical along with online, physical will also continue, under the new legislation, one of the provision is made, state commission can sit in different places of the state. Now, Karnataka State Commission is in Bangalore. They can sit in Dharwad. Recently, there was a program, new building form ceremony happened in Dharwad. The State Commission President was here, Registrar was here, Additional Secretary was here, and Minister was also here. So the Dharwad Bar Association requested, we want one permanent bench in Dharwad along with the High Court. They requested. So that can be done. Or otherwise, if even that is not there, under the Act itself, state can prescribe, direct the State Commission, you sit 1 month in Dharwad. So they should do that. So that provision is made. And similarly, District Commission, in district place they are sitting, state government may direct, you go to this particular taluk and sit for 1 week. They should go and handle that area cases. So that provision is also there under the new legislation. So both the things will satisfy that particular concern.
Thank you, sir. The final question, are intermediary guidelines 2021 applicable to marketplace e-commerce entities?
Yeah, under the Consumer Protection Act 2019, rules are framed, e-commerce rules are framed. Under that, clearly mentioned, intermediary rules of IT Act are applicable. Clearly mentioned that. So duties and responsibilities of intermediary are even under the Section 73 of IT Act, clearly those are also used. So everything, those intermediate rules are also applicable here. They have to prove due diligence, whatever provisions are there, they have to prove, and expressly mentioned under e-commerce rules, what are the duties and responsibilities. If they fail to do that, automatically they are held liable. And there is a new amendment is happening. Every e-commerce company is afraid of that implementation. So once that amendment happens, then it will be e-commerce and e-consumers will be protected more strongly against the exploitation.
Thank you, sir. May I request Srimati Archana K, Assistant Professor, KSLU's Law School, to kindly deliver the vote of thanks. Please, ma'am.
Good afternoon to all. It's my proud privilege to propose vote of thanks on this occasion. First of all, on behalf of Karnataka State Law University's Law School, and on behalf of the organizing team, I convey our gratitude and heartiest thanks to today's resource person, Professor Dr. Ashok R. Patil, for accepting our invitation and consenting to deliver this special lecture on 1 year completion of Consumer Protection Act 2019, achievements and challenges. Sir, your lecture was very useful and interesting. Through your scholarly presentation, you have provided us much food for thought. I'm sure all the participants of today have benefited by listening to you. Thank you, sir. I profusely thank Honorable Vice Chancellor, Professor Dr. P. Ishwar Bhatt, a well-known legal luminary, for encouraging and guiding us to organize this special lecture. Thank you, sir. I express my deep sense of gratitude to Professor Dr. Ratna R. Bharamkauder, Dean of KSLU and Director of KSLU's Law School, for giving me the opportunity to organize this special lecture, and also for her unfaltering support to organize this special lecture. Madam, once again, we thank you for supporting and guiding us in each and every point of time. I convey my sincere thanks to Sri Mohammad Zubair, KAS, the Registrar Administration KSLU, for his support in organizing this special lecture successfully. Thank you, sir. I thank Professor Dr. G.B. Patil, Registrar Evaluation of KSLU, and Professor Dr. C.S. Patil, former Dean of KSLU, who backed and supported us in this endeavor. I thank them for their gracious presence. Thank you, sirs. I thank all the invitees, faculty members, and students for their participation to make this special lecture a grand success. And I would be failing in my duty if I do not take the name of the faculty members who gave us unconditional support from the back end. Our sincere thanks to Mr. Girish Gowda Patil, Assistant Professor of Management, who did all the groundwork in organizing this special lecture. Thank you, sir. I thank our student, Ms. Ramya Hegde, for her efficient and effective comparing. Thank you, Ramya. Lastly, I express our special thanks to all my colleagues and students and to all the members of KSLU's family for their unrestricted help and support in organizing this special lecture. Thank you one and all.
Thank you, ma'am.
Thank you.
Professor Ashok Patil, thank you so much.
Thank you. Thank you
It was
very much.
very exhaustive and highly informative. Thank you so much.
Thank you. Thank you very much, sir.
Thank you.
Thank you.
I thank all the participants, and we will wind up this program. Thank you.
Thank you.
Shall we
ma'am.
adjourn for the day, ma'am?
We will wind up the program. And
We
the
adjourn
classes
for
will,
the.
yes, and classes will go on. The next classes will go on. Okay.
Yes,
Thank you.
we adjourn for
Thank
the day. I wish everyone a good day. Thank you.